I've had a few questions recently about COVID-19 disclaimers. So thankfully, businesses are starting to open in Massachusetts, and some business owners are concerned. What if a patron or a visitor gets COVID-19 and they sue the business? And in reaction to this, a lot of people are drafting disclaimers and having their clients sign the disclaimers. So just a few uh, general observations about this whole thing. First of all, I think it's very difficult to prove by a preponderance of the evidence that a person contracted or picked up a virus that you can't see at a certain place at a certain time. Now, that doesn't mean that it will stop lawyers from trying to prove that or from making the argument or just suing a business and hoping that the business will pay some money to settle. But I think it's very hard to prove. Second, if it is proved, the fact that COVID-19 is not really a threat to the vast majority of people who get it doesn't mean that if somebody does get it and they have a bad reaction, they actually die from it, that you're not on the hook for that. Okay, here in Massachusetts, we observe the eggshell plaintiff rule. So if you're negligent and somebody suffers from that in an extreme way due to a pre-existing condition, you are still liable for the full amount of the damage that your negligence has caused. Now, with that in mind, these disclaimers, a few general observations of the bare minimum things that should be included. So first of all, the patron or the visitor has to state that in consideration for entering the premises or coming into your business or whatever it is, they are signing the release, right? Or they are releasing any claims that they may have against you due to COVID-19. So first of all, there has to be a statement that it's for consideration, that the agreement's being signed, all right, consideration for entering the property. Secondly, the person signing it should acknowledge that they're aware of the risks of COVID-19 and they're aware of the state guidelines and so forth. Second, in light of that knowledge, they are still willing to take the risk and still willing to enter your business or your property, whatever it may be, whether it's a health club, a pool, whatever it is, they're still willing to take the risk. You want them to agree to indemnify you if they ultimately do sue you and you have to defend yourself. If you win, they're agreeing to pay your legal fees, your court costs, and everything associated with the lawsuit. And it should state that the patron is signing on behalf of a minor, if there's a minor involved, and that they have the legal authority to do that, right? And those are the bare basics, the bare minimums, and it could go on for a lot longer with all sorts of provisions. But at the very least, it should have those provisions. And if you're running a business and you want somebody to come in and give you their money, you obviously don't want them to sign anything that's over the top or multiple pages long. Maybe just a half page to a full page waiver should be sufficient. And these disclaimers really haven't been tested yet. And just having somebody sign a disclaimer may not stop a lawyer from suing you, so keep that in mind as well. If you have questions, contact me. If you want a disclaimer written, please send me an email, and I'd be happy to work with you. Thank you.